Hello everyone and welcome back to the channel. In this video we will be looking at a brief overview of minority shareholder protection in UK company law. We'll start by understanding the basic right of shareholders, then move to the rule in Voss versus Harbottle, the idea of majority control, and finally we'll look at exceptions and the statutory remedies available under the Companies Act 2006 and the Insolvency Act 1986. This topic is central to company law because it explores the balance between two key ideas: that the majority should be able to run the company, but conversely, that the minority still deserves protection when things go wrong. All right, let's begin. Let's start with the basics. Shareholders are members of the company. They own part of the company through shares, but they don't manage it day to day. That's the director's job. However, shareholders do have certain powers and rights, which come mainly from the Companies Act 2006 and from the company's Articles of Association. Typical rights include the right to receive a share certificate under Section 768, to transfer shares under Section 544, to receive dividends, and to vote in general meetings. That's Section 284. They also have a right to share in any residual wealth. In other words, any wealth that is left over after all of the creditors have been paid, if the company is wound up under the Insolvency Act 1986. So even though shareholders don't run the company, we're talking about the bigger companies, there's usually a big distinction between the directors who run the company and the shareholders who own shares in the company. Nevertheless, shareholders are still central to the ownership and ultimate control of the company. At common law, shareholders faced a big problem when trying to challenge wrongdoing inside of the company. This problem is summarized by the rule in Voss versus Harbottle, which comes from the eponymous case that was decided in 1843. This rule has two limbs. Firstly, the majority rule principle. This means that the majority of the shareholders can decide what the company does, even if the minority disagrees. The second limb is the proper claimant rule. If the company has been wronged, the company itself, not the individual shareholders, is the correct party to sue. Now, why does this matter? Because the company is a separate legal person. It owns its own property and can sue or be sued in its own name. Allowing every shareholder to sue individually would lead to chaos, a multiplicity of actions and conflicting court orders. So in short, Voss versus Harbottle, or the rule in Voss versus Harbottle, tells us that majority rule governs corporate decision-making and only the company can enforce its own rights. So when you buy shares, you agree to be bound by the company's Articles of Association, which I abbreviate here AOA. This means you're effectively signing up to the idea of majority rule. As the court said in Voss versus Harbottle, every member of the company is bound by decisions made at a general meeting as long as they're made properly. That's part of the corporate democracy. Sometimes your vote wins, sometimes it doesn't. This principle helps companies function smoothly and prevents endless litigation over internal disagreements. Let's look at what the case actually decided. In Voss versus Harbottle, a shareholder, Voss, sued the directors of the company, alleging that the directors had defrauded the company by selling land to it at an inflated price. The company was by this time in a state of disorganization, and efforts to call the directors to account at a general meeting had failed. The court held that the company as a separate legal person is the only proper claimant when its rights or property have been infringed. Secondly, it's for the company acting through its members in general meeting to decide whether to bring legal proceedings or not. So, even if the directors have done something wrong, individual shareholders cannot normally sue. It's up to the company as a whole to decide. Now, this might sound unfair, but it preserves the principle that a company acts through the majority of its members. So what does this mean in practice? Ultimate control of a company rests with the members voting in general meeting. It also means that directors owe their duties to the company, and this is taken to mean the members as a collective body, not to any individual shareholders. If directors breach their duties, it's the company that must sue, not the shareholders. The company is seen as the victim. That's the proper claimant principle in action. There's only one statutory exception to this. Under Section 168 of the Companies Act 2006, shareholders can vote to remove a director by an ordinary resolution. And you'll remember that an ordinary resolution is just an ordinary vote in favor of something, meaning that just over 50%, just over half of the shareholders have to vote in favor. And this means that that directors have quite a precarious position. They can be removed quite easily. And this is the reason why. So if shareholders don't like what directors are doing, the solution is to remove or replace the director. However, there are several ways in which a minority shareholder can nevertheless bring a claim. Firstly, we've got personal actions. These are actions that a shareholder can pursue when their personal rights are infringed. By personal rights, we mean their rights as shareholders. And these rights are, for example, where they are denied a vote or where a dividend is declared and they're then not given a dividend. So it's only shareholder rights that can be vindicated, not any rights of the company, only the rights of the shareholder. Secondly, we've got representative actions. This is where one shareholder represents others in a similar position, but once again, the only rights that can be vindicated here are shareholder rights, so votes or dividends, not any rights of the company. And then we get to derivative actions. Now, this is where a shareholder brings a claim on behalf of the company itself, not based on a shareholder right being infringed, but based on a harm done to the company. We will be looking at this in a lot of detail in a separate video, and we'll just very quickly delve into this a little bit further in this lecture. So then there's also a very powerful tool for minority shareholders in the unfair prejudice petition. Under Section 994 of the Companies Act 2006. We'll look at this as well in a separate lecture, but also explain it a little bit more in this lecture. So although Voss versus Harbottle sets a strict rule of the majority rules in a company, modern company law has developed several escape routes for minority shareholders. Let's just look at the common law first. Under the common law, they recognized certain main situations where a shareholder can take action, even though, strictly speaking, the company should be the claimant. So these are the common law exceptions to Voss versus Harbottle. Firstly, ultra vires acts. This is where the company or the directors of the company act beyond their powers. Then we have illegal actions. This is where the act complained of is unlawful. Third, failure to observe internal procedures, for example, where decisions weren't properly authorized or voted on. And finally, the big one, fraud on the minority. Fraud on the minority happens when those in control, either the directors or the majority shareholders, divert company property or benefits that should have gone to the company for themselves. A classic example is the case of Cook versus Deeks, 1916 case, where 3 directors excluded the 4th and took a contract for themselves instead of the contract going to the company. The court said that this was a fraud on the minority and the majority's decision couldn't stand. So what remedies exist today? Well, the nuclear option, the last resort, would be a just and equitable winding up under Section 122 of the Insolvency Act. This is often the last resort because, in effect, it means that the company will come to an end. But there are also statutory remedies under the Companies Act 2006, including the derivative action and the unfair prejudice petition, which we'll look at separately. The common law exceptions we've just looked at now, which, just to recap, include ultra vires actions and illegal acts that can be challenged, or actions that boil down to a fraud on the minority. In practice, most shareholders will choose to bring a statutory claim because these are clearer and more predictable than relying on the old common law, case law exceptions. In this slide, we've got a flow chart which ideally helps you to decide which action to take. So ask yourself, has a personal right been infringed? If yes, so personal right would be, for example, where you are a shareholder and you were denied a vote in a general meeting. So if the answer to that is yes, the shareholder can bring a personal action or an unfair prejudice petition under Section 994. If no, In other words, if the issue involves a harm to the company, such as, for example, a breach of duty by directors, then the shareholders might bring a derivative action under sections 260 to 264. They could also bring an unfair prejudice petition. So you'll note that the unfair prejudice petition is available to both personal actions as well as actions by minority shareholders on behalf of the company. If the relationship between the shareholders and the company has completely broken down, the last resort is to seek a winding up on just and equitable grounds under Section 122 of the Insolvency Act. So as you can see, the law tries to offer a spectrum of remedies from targeted action to complete dissolution. Finally, to sum up, minority shareholders are not powerless, although in general they have to abide by what the majority decides. They have several key protections. First, the derivative action. This is an action to enforce the company's rights when the directors won't. Then there's the unfair prejudice petition. This is where the company's affairs is unfair either to the company or to the shareholders. And finally, a just and equitable winding up when the relationship completely broke down irreparably. The aim is to balance fairness with efficiency, protecting the minority without paralyzing the company. So while Voss versus Harbottle established majority control, modern company law ensures that this power isn't abused. So that's our introduction to minority shareholder protection. And we've seen how the rule in Voss versus Harbottle gives the majority the right to control the company, but also how the law provides protection under statute and in common law to prevent abuse. In separate videos, we look at these issues in more detail. We look at how the derivative action works, and we also look in a separate video how the unfair prejudice petition works and can be pursued. Thanks for watching, and if you found this useful, don't forget to like, subscribe, and also check the channel for more videos on company law.